Hello, everyone. Welcome back to the Global Digital Asset Regulatory Summit. We have been around the world today. We're currently focusing on Australia. We just had a conversation around custody. We're going to jump into consumer protection now. A massive conversation happening in Australia around consumer protection. It is probably front and centre for our regulators and the Australian government at the moment, I think it's safe to say. We're about to jump into a panel session. Tim Edwards from Hopwood Gaddam Lawyers is going to be moderating a session alongside Liam Hennessy from Clyde & Close, Delia Burrage from Katina Digital, and David Menz from Coinbase. An all-star lineup. I will pop them onto the stage now. We're doing well. Well, my tech skills are not so bad. Here we go. Five seconds, and we're in.
Recording in progress.
All right, Tim.
All right, thank you very much, Amy Rose. We're live. Hi, everyone, and thanks for tuning in on a Friday afternoon to talk about consumer protection and market integrity in the context of the Australian digital asset industry. We've only got 30 minutes, and I understand Amy Rose has already kindly introduced us, so we'll dive straight in. We were going to tackle this topic through three questions or subtopics, being first, what are the concepts of consumer protection and market integrity, and what in particular do they mean for the digital asset space? Secondly, what can industry participants do to manage the risks associated with those concepts? And thirdly, how are those topics being treated in Australia at a policy level, and what's in the pipeline? So before we get into that, though, I wanted to set the scene in a really ominous way. Not a litigator monologue, don't worry, but that's what I am, so I can't help it. Then I'll shut up and we'll hear from these experts. So we are still early, yes, but this industry is maturing. One symptom of a growing industry is an active regulator. Our regulator, the key one, ASIC, seems to have become far more litigious and minded to run what some might describe as test cases in the past 12 months. There's some regulatory uncertainty, and litigation appears to be seeking to try to plug that gap. A lot of that litigation appears intended to bring about consumer protection outcomes. There's elements of this in litigation involving Block Earner, Finder, Coin with a Q, Kraken, and others. But not only that, some of these cases have been prosecuted in ways which appear intended to send messages of deterrence. That's important because some centre on the categorisation of products that were recalled before or as the litigation began. So when further conceivable actual harm flowing from that had already stopped, but ASIC's pushed on anyway, seeking penalties. Seems very likely there's more of this to come. And if you want to avoid fun litigation with a regulator, which sucks whether you win or lose, by the way, for everyone except the likes of me, you need to understand more than just the black and white of what the law says. You need to understand what our regulators are trying to do and protect over the top of all of that. So with that ominous segue aside, onto the first topic. And Delia, I'm going to start picking on you first. Can you talk us through your perspective on consumer protection? What do we mean by it? Who's the consumer in focus here?
Sure, thanks, Tim. So consumer protection generally means safeguarding consumers' interest rights and safety in their interactions with business and the marketplace, which is necessary due to the asymmetry of power and information between consumers and other market participants. The consumer that governments and regulators are trying to protect generally differs depending on the individual regulation. So as you would be aware, there are a large number of laws that protect consumers from physical harm in product safety, but in the digital space, we're primarily talking about two sources of requirements. One is the Competition and Consumer Act, which includes the Australian Consumer Law, the ACL. It's regulated and enforced by the Australian Competition and Consumer Commission, the ACCC. For the ACL, a consumer is a person or business that acquires goods or services that are normally used for personal, domestic, or household purposes. It's not limited to individuals, and the focus is on the product. While the expression domestic and household might make you think of couches and cleaning products, digital products that are available to a general public are likely to be caught by the ACL, including crypto assets sold to the general public, generally available smart contract or DApp services, NFTs, or digital or on-chain products that are made available, digital or on-chain financial products that are made available to consumers. even though those are also caught by the consumer protection provisions in the Corporations Act, which are administered by ASIC. So those break down to market misconduct, some of the fundraising provisions in Chapter 6D, and particularly Chapter 7, which deals with financial products and services. For ASIC purposes, a consumer is a retail client who is, there's a long definition, but basically it means not a wholesale client, and there's a long definition that goes with that. It's really important to get across what those definitions mean to understand whether what you're offering is a financial product or service, and who you're offering it to, whether they could fall into the definition of retail. You really need to get legal advice on that because it is complex. There are some simple ways to avoid having to have those consumer protection provisions apply, such as if you've got a digital investment product, limiting that to an investment of a minimum of $500,000 will mean that you can treat those investors as wholesale and not retail. If you want to see how ASIC has applied those provisions to the laws that it oversees, have a look at Information Sheet 225. It sets out a number of ways that the existing regulatory framework applies to consumer protection and to digital assets. There's other consumer definitions that go with the Privacy Act and with the consumer data rights. So the key message is identify the laws that apply to your proposed product. Then analyse whether the market or a segment of the market for that product will be treated as a consumer under those various laws. If necessary, make some adjustments to the product that you're proposing to issue to either exclude those consumers or to comply with those more onerous requirements.
Makes sense. And the thing that jumped out at me there, especially with some of the stuff we've seen in the media lately, is the goal to protect consumers from certain information and power asymmetry. So if the goal is that protection, what are some of the primary concerns you think of regulators in terms of adverse outcomes that they're trying to guard against with what they're doing?
Yeah, sure. So really, as within the framework of looking at information asymmetry and power imbalance, the regulators have really addressed this by looking at disclosure and in terms of rules related to conduct. So what does a business say about the product, how it's going to work, what representations were made about the likely outcomes for the consumer and the potential risks? Was the information misleading? Were the risks as prominently disclosed as the benefits? If you're looking at where those risks have manifested and the sort of outcomes that regulators are trying to avoid by administering these rules, the biggest one is scams, which hopefully nobody listening here will be trying to perpetrate. But by far and away, the biggest harm has come from scams. So fraud and scam risk, including drug pools, pig butchering, romance scams, loss of access to tokens due to account takeovers, scams that expose consumers to other harms beyond the assets purchased, such as cyber risk. There's also negative outcomes from misleading and deceptive conduct. So higher costs than were disclosed, a lack of competition that's driving up prices, lower functionality than expected by the consumer, lower liquidity than was disclosed by the issuer. It's also around market manipulation, leading to lower returns. So, for example, pump and dump schemes in lower liquidity tokens. Poor risk management can lead to negative outcomes such as stablecoins that depeg because the reserves were not appropriate or the algorithmic stabilization didn't work. Unfair contract terms leading to consumers being locked into products that they can't leave or that had features that they didn't want. And things like loss of privacy and data control. So data being sold, potentially leading to identity theft and other scams.
Okay, thank you. Well, one more question for you, and it's an annoying one, and then I'm going to pick on Liam. What do you think? So those are the key adverse outcomes we think the regulators are trying to stop. What's actually driving them, though? What's causing them? Sure.
So there's a number of reasons why consumers are losing money and suffering harm. Obviously, the prevalence of scams has been the biggest focus of government and regulators. And just to put some numbers around that, in 2023-24, Australians lost around $180 million to crypto-related investment scams, which was nearly half the total amount of money lost on investment scams, sorry. which represents around 600,000 scams. A part of that is just the novelty of the technology. So consumers are simply not able to recognise that they're being led up the garden path. Partly it's because there's been a bit of a gold rush in terms of trying to get the returns that crypto can offer, which is leading to consumers making risky behaviours. Partly it's about the global nature of the industry and the social media channels that are promoting some of the scams. So tech limitations on being able to deal with those systemically by platforms, and also the regulators' limited powers being able to deal with global organisations. I mean, the ACCC, for example, has been in litigation with Meta for really over 2 years, trying to get Facebook to do more about the 58% of crypto ads that are actually scams. So some of the things that are not scams, that are other behaviours that ASIC is clearly concerned about, relate to behaviours of product issuers and product distributors. And partly these can be generated just by the lack of understanding of some product providers about how the law applies to them. And that would certainly be improved by the government prioritising the legislation that has been proposed by Treasury, so that there could be greater clarity about what they have to do going forward, leading to fewer negative consumer outcomes and a lot less litigation. So I'll let others talk about that. So some of the problems that can arise from an issuer perspective is inadequate risk disclosure, including in relation to returns, reserved asset use and liquidity. Some misleading and deceptive conduct, which can often be quite inadvertent, just overly enthusiastic marketing, for example, that didn't really say some of the risks appropriately or what the functionality of a product was, and competition issues such as third line forcing. Decentralised or international organisations can make it difficult for consumers to seek redress. And one sobering statistic is that 50,000 Australians were caught up in the FTX collapse, for example, making it difficult to get redress. And other aspects of the technology, such as the ability of stolen assets to be able to disappear fairly quickly onto international platforms.
Thank you so much. I'm sure a lot of that resonates with a lot of the people watching us right now. And something that jumps out at me there is relevant to even just the cases I mentioned before. Over-enthusiastic marketing. It's one thing. It's very easy to say, oh, run every single marketing external piece past a lawyer, but that would bankrupt most of the players in the industry and maybe more. So how to do this in practice is difficult. Again, so now's the time where I'm going to ask Liam to give everyone watching free binding legal advice. I'm so sorry. Liam, what would you say are the core themes that businesses need to be thinking about in their approach to market integrity and relationships with consumers?
Yeah, thanks, Tim, and thanks, Delia. That was a really great intro. So, I mean, consumer protection is absolutely critical in all financial services and broader industries. What the goals of consumer protection in terms of fair treatment of consumers, transparency, ethical conduct, protection against harm and so forth are well known and a prerequisite of a properly functioning market, including the Web3 market. One of the great macro trends following the GFC is this swing for policymakers and regulators globally to focus more on protectionism in terms of consumers, and therefore, if there, and what I mean by that is if there is consumer harm, they're placing a lot more on the onus on the financial services business, the Web3 business, to remediate that harm. And our legislation and our regulation is reflecting that in this day and age. It used to be the case about 20 years ago that the idea that you can do, generally speaking, quite a large range of things with your products, and provided that you disclosed it appropriately, then that was sufficient from a consumer protection point of view. But that view has definitely evolved to the point where we are now, where we understand that disclosure is one piece of the puzzle in affecting good outcomes for consumers. There are a range of consumer protection infrastructure in place that is mandated by law, whether that's disclosure requirements around product disclosure statements, information memorandums, financial services guides, whether there's complaint resolution mechanisms, client money handling mechanisms, various statutory cooling off periods, and so forth. The challenge is taking all of that relatively complex financial services regulatory law and applying it into a Web3 context where we've got this market that is financializing at a rate of knots. And I think everyone on this call will have an idea that it's very likely that AFSL licensing is going to come into play for digital assets, around 2025, and certainly for stable coins under the payments legislation. So people are turning their mind to that now. And in particular, what are the new requirements, or at least the enhanced requirements, where you're dealing with a market characterized by the complexity of that, the blockchain over traditional financial products. There's certainly a world of opportunity that exists there in terms of product design and in terms of business design. You can tokenize commodities like gold or silver or land. You can tokenize funds management financial products to make them more efficient, to make them perform more functions that they're able to do in terms of voting, in terms of coupon issuances, and to really meet consumer needs in a much more nuanced way to them. That also applies to consumer protection as well. Meeting the complexity of the challenge needs to be considered in light of the new tools that are available with Web3 to meet that complexity. And what my practical suggestion is, and what we tend to do when we're working with product issuers or licensing for whether it be a trading house, whether it be a funds management business, is to really work from the ground up in terms of, look, let's get into your operations and see how the money flows from A to B. Let's see how the disclosure works from A to B. Let's see what the customer journey is from A to B. It is relatively straightforward to give legal advice on any one of a number of these issues, but the devil and the complexity and the challenge comes in the operations. So mapping out your disclosure requirements, mapping out your operational requirements in terms of how money flows and how your treasury works, mapping out your customer journey is absolutely critical. That's where a large range of the issues occur in this market. And where there are challenges identified, it may be, processing payments and so forth. And because of the speed of Web3, you need to aggregate batching and do it automatically. It may be the fact that your product design journey, to Delia's point earlier on with PDSs, we have a whole lot of developers who are designing products at the start of it, and it's not a traditional financial services market where a bunch of people get around and create a PDS together, and that is the product, and then it's issued to the market. Often, the lawyers, the other advisors are creating a PDS or a disclosure document after the fact to fit the nature of that Web3 asset, which can present its own challenges. Getting your head around those nuances is absolutely critical in this market for the protection of the consumer and for the business itself.
I think you've answered the next question I was going to ask too. I was going to ask for probably your 3 top practical tips of people looking to, before they start anything, looking to come and get legal advice from you when designing a product. It sounds like the main tip is involve your advisors early. Think about the end game at the start. Fully support that. Makes perfect sense to me. I was wondering if you could drill a little further into the topic of disclosure. And I know you touched on it a bit, but just how key that is in the context of market integrity and consumer protection.
Yes, absolutely. I mean, disclosure is, to Delia's point, absolutely critical because there is an informational asymmetry, as there are indeed in all financial services markets, but increasingly so in a Web3 market, given its complexity, cross-border nature, and the different features that a product can exhibit. Getting the disclosure right involves some pretty nuanced discussion with your advisors from a very early stage, and not only being able to disclose what the product features are and the rights associated with them, but also to do that in a way that is very clear and efficient for the consumer. My suggestion in that stage is certainly work with your advisors early, certainly make sure that your advisors have the skill set in financial services, regulatory and Web3 to be able to advise. But also, frankly, and it may not be a popular opinion, test your legal advisors in terms of, look, we think this is how the product journey is going to work. Can you map it out for us and explain to us all of the different traps along the way from A to B? Because if you're asking for a legal advice on one discrete point here, that can sometimes miss the wider picture. So making sure that you have a bit of a holistic approach in terms of how you brief external advisors and making sure that they understand it from A to B and can advise you on the potential shortfalls in that journey is pretty critical from my perspective.
Okay, thank you very much. Makes sense. I do have more questions for you, but I don't want to let David get away while we've got him trapped here. So I'm moving on to you, David. Got nowhere to run.
On, David.
That's it. That's it. So David, without asking you to breach anything, or you can, it's up to you, given your prior experience, background, and even what you're seeing in your new role, can you talk to how market integrity and consumer protection themes are playing out in Australia at a policy level now?
Yeah, thanks, Tim. I guess I've sort of taken a little time to sort of think about this in my time off in between jobs. And really, it comes down to a journey, and it has been a journey. Like Bitcoin has been around since 2009. We're talking about major changes to how these things may be regulated at this point in time. Like we've come a long way. There's been a lot of time where potentially we could have made a change and regulated in a way along the way. So why do we choose to create new policy? Why is there what is the point in time in which like the government says, okay, we've got to do something new here? We've got all of these consumer protections in place already. Delia and Liam sort of went through a whole bunch of them. There are laws that always exist, and no product is invented in a vacuum without those laws applying already. So when do you intervene from a policy point? And it's generally when there's a market failure. ASIC and the government sort of look at Bitcoin early. We've got the Senate inquiry discussion from ASIC that came out in 2014, but we're 10 years later and we still sort of don't have a framework. And that's, I would say, because although there have been little failures along the way, the real call to arms was the FTX collapse. It affected a huge amount of people around the world, and just like a much wider variety of people than had been sort of previously interacting with failures across the crypto sphere. And so this is kind of our big sort of, this is a market failure. We need to introduce new policy. And you kind of see that in the Treasury's paper in regards to how we're thinking, how Australia is thinking about potentially regulating digital asset platforms. That focus on the extreme mismatch between customer expectations, consumer expectations. Did I buy something? Do I have access to it? Is it still mine? And the outcome, oh no, we never actually bought that. We just sort of represented to you that that existed on our balance sheet. And sorry, we actually held a whole bunch of other things. That is a huge gap, and that's clearly a market failure. There are little variations of this sort of along the way as how different digital asset platforms have performed poorly in the eyes of the consumers, but that's really like where we're looking at it. And so you kind of see that come out. Closing those mismatches between consumer expectations and true outcomes, as Delia said, like that concept of asymmetry is where we would sort of consider creating new policy and creating new legislation. We have to have a bar to step over. We don't just create policy because something exists. It has to require it as well. And so that focus is kind of your really consumer protection side of things. And then you add sort of little layers on top of that. You look at the consultation paper, and it talks about things like, how do we do product disclosure or similar things like token disclosure? How do we ensure that people understand what the platform's sort of minimum requirements are to provide to provide the service to their users? all of those things then sort of start to build a form of what I consider like a weak form market integrity. So market integrity is kind of really there in a weak form and strong form definition. In a weak form of definition, we're really talking about all of the things that allow people to interact with each other in a marketplace broadly. Consumers, consume things from markets or marketers. And then if we talk about like the strong form version of market integrity, in the way that I consider this is like, how do we think about market integrity for capital formation across an economy? And you would sort of be right in thinking that the paper sort of balanced those a little bit, not as equal as you could have otherwise. So clearly the focus is on consumer protection. There are small little tags in regards to that strong form market integrity. There's questions in there about the how should these markets be thought of. There's retail participation, but some of these things aren't financial products. We don't really have direct participation in many markets because of that. And so, it's a really interesting thing. I'm hoping that the feedback that was provided by everyone was sort of taken on board, and whatever ends up in draft legislation sort of looks at that. But I think that, like, we do see it makes sense. You get the consumer protection right, market integrity can like come along and hopefully be improved further down the line.
A brilliant answer, because it even answers the next question I had for you as well. Now, this is super unfair because we've got 1 minute left before I get banned from ever moderating a panel again. But in 1 minute, David, how are we comparing internationally? Give me a rating out of 10.
I'm not going to give a rating out of 10.
That's fair.
I think that it's good that Australia is looking at it. I hope that we do see the government prioritize their timelines that they set out in the paper. And I think that we would all like to see that sooner rather than later. One thing that I guess I sort of think about this is, how are consumer protection and sort of market integrities flowing through rules that are being created for these businesses around the world. And now my new sort of home country of Singapore, you see it being looked at in a different way. It's a very, very strong focus on consumer protection. The focus on market integrity is there. There are some guidelines, make sure that people aren't directly manipulating order books, make sure that people aren't, sort of messing around in ways that they shouldn't. But like they're really in the guidelines, whereas that focus is heavily on consumer protection. They started out, you couldn't access as a retail participant. Then they opened it up, and there are, you cannot advertise. And so like the idea of restricting access is this sort of true spectrum that we're talking about. How do you protect consumers? Well, you can just stop them accessing something, but does that work? And I think that we've seen in some places around the world, the more heavily you go at consumer protection, the more likely that you just push these people offshore into unprotected markets. There are multiple jurisdictions where heavy-handed on consumer protection has seen all of the activity of those consumers of that country go to places that you probably wouldn't want to see your consumers interacting with as their primary source of interaction for this. So maybe we can find a balance.
An astoundingly good answer given the rubbish setup I gave you. Thank you very much. We're getting gonged, we're out of time. Thanks, Deca. Thanks, panelists.
Thanks so much. Look, David, that was a mic drop too. So that is a good end to the session. Let's not push everyone offshore, hey? All right, we're going to jump into the UAE now for the next session. So I'm going to love you and leave you here, and all of the attendees, both here and in the lobby, which I do wish you would just join some of these webinars. Just click join if you want to, rather than sitting there watching it in the lobby. All right, we shall see you shortly. Thank you, everyone.